myself. My name is Amy Tripp. I am with HRsimple. We publish state-specific human resources manuals for employers, covering topics, from anything from pre-hire through post-termination and everything in between. With every manual, you get free access to these webinars that we do every month. We do 1 to 2 a month. So I will put a link to purchase those for anybody who's not a current subscriber in the chat, and a 20% discount code. Now, with that out of the way, I want to introduce our amazing speakers, 2 of my favorite people to work with. Pete Gillespie and Katherine Stryker are both joining us from Laner Muchin. Did I get that right, Pete?
Second time, yeah.
Muchin. Every time.
Sometimes always a charm, right?
Right. They're both employment law attorneys based here in Illinois. Pete actually authors our Illinois State Human Resources Manual, and Pete and Katherine have both joined us before to present for webinars, and they are the most requested to have back. So we're so lucky to have you guys. Thank you so much for joining us today.
Oh, thank you. It's always our pleasure to be here, and feeling a little nervous with that buildup of how we do today. But yeah, thank you. My name is Pete Gillespie, and I've been practicing law for over 25 years. Hate to admit it, because obviously I'm the Doogie Howser of lawyers. And we do management side labor and employment here at Laner Muchin. I am the office's health and safety lead on those kinds of claims, and also do a lot of counseling and advice on developing policies around drug and alcohol, and in particular have been very busy with cannabis as the states have started to legalize. Katherine, do you want to say hello and introduce yourself?
Sure. So my name is Katherine Stryker. I haven't been practicing as long as Pete, but I have focused my career so far on employment litigation. And I also here at Laner Muchin do some counseling and advice as well.
So we're here today to talk about cannabis. And really, I welcome the chance to talk about cannabis, primarily because I welcome the chance to talk about anything but the pandemic. And we thought that it was appropriate, given that employers are coming back into work more, and employees are coming back, to really start focusing in on workplace issues. And cannabis in particular has been a challenging topic for a number of years now, because primarily it's the issue of states and municipalities running ahead of what the federal law is. And so, for example, in Illinois, cannabis has been legal for recreational use for a number of years now, from the before times, pre-pandemic. And so employers have had to grapple with issues of, well, it's legal off-duty, and there are protections in Illinois for off-duty use of lawful products that apply to cannabis, despite the fact that on the federal level, it's still technically illegal. And so navigating these issues of, the cannabis is legal in a lot of jurisdictions now, employees are going to be using it on a much more frequent basis than perhaps they did in the past. Your rights as an employer are changing in terms of how you can enforce a cannabis policy or the cannabis portion of your drug and alcohol policy. And there are also increasingly a number of issues arising from the fact that the legalization of hemp and the investigation of low THC products, CBD type products, there are medicinal reasons why individuals may be using cannabis in certain states. That's all you can do is have a medical card for cannabis. But, more often, we are seeing claims and situations where the employee is bringing up a medical, seemingly valid reason for off-duty cannabis use. And there are questions that come out of, well, what do we do with that information? And how can we respond to that appropriately? Because, as we'll get into, there's a balance between you want to accommodate, employees who have legitimate concerns. You may be required to accommodate employees who have legitimate concerns. But, from my perspective, you lose what we used to have in terms of a deterrent effect of an enforceable drug and alcohol policy. Because when cannabis wasn't legal, I didn't get a lot of questions about how do you enforce, because the questions were really, really easy. Cannabis isn't legal. We have a policy that says you can't engage in illegal conduct. Courts are going to uphold a policy that says you can't engage in illegal conduct. The cannabis test we'll talk about, looks back 2-3 weeks, possibly even a month. So it's really hard to use cannabis recreationally if you have a policy that says, if we test you, we can let you go, and a judge saying, yes, that's a valid and enforceable policy. The landscape has changed a lot. That deterrent effect has changed and is reduced in many states. And yet we have this overarching issue of, regardless of if you can point to a DOT policy or a drug-free workplace requirement or anything else, we want to keep your workplaces safe. And, there are concerns about that we'll have to navigate through. So hopefully that's why you're all here, because that's what we're intending to cover for you today. So, from a broad perspective, substance abuse in the workplace, can touch on a lot of different issues, in terms of your policies that you have, safety issues, whether, you may need employees going to an EAP for substance abuse treatment, whether or not somebody can pass a drug test might in some states affect their ability to bring an unemployment claim in an injury situation. And in some cases, the use of products like cannabis, or CBD that has the THC count that would trip a drug test, may be ADA implicated. And when you're looking at your drug policy, you can't silo it into just, well, what does my drug and alcohol policy say? Because it will impact and intersect with a lot of other issues that are potentially out there. Because generally speaking, we want policies that you can enforce, and we want policies that you can enforce on a uniform basis, so that when you're disciplining based on your policy, you're not opening yourself up to a claim of discrimination saying, well, this other person was allowed to do it, or, and why can't I get away with it? Is it because of a protected issue? And then, you're calling a lawyer, trying to figure out how to navigate your way out from underneath it. And, so we will be, as we're going through, touching on a lot of different angles that can be impacted by your drug and alcohol policies, and in particular, cannabis and under these policies. State laws, they are always changing. This map is intended to try to give you, some understanding as to where things stand currently in the U.S. with, state level legalization of cannabis restrictions. Different states are taking different approaches. And, the green states, are typically full legalization. Yellow states, would be, you're looking at, states that would allow for medical cards and medical use. And, it's important to understand that because things are being done at the state level, not the federal level, they're changing all the time. And so, for example, if you're on from Maryland, congratulations. Come July 1, my map's going to be out of date because, Maryland will be, as I understand it, legalizing cannabis for recreational use effective July 1. And so, the color on Maryland is going to change from yellow to green. And we'll be talking a little bit about, how your policy should look and what you should be thinking about from an enforcement perspective, depending on whether your state, has fully legalized cannabis for recreational use, or if it's just a medical situation, because, it depends. And then, the other layer to look at would be, whether or not employers have to address the fact that legalization, either for medical or for recreational use, are there also employee protections that are in place? In Illinois, we're in a situation where it's legal for recreational use and there are employee protections in place, because in Illinois, off-duty use of legal products is protected. The Maryland example, is a little bit different in that, yes, it will be legalized, but as I understand it, as of right now, there are no rules that would be in place that would talk about protections for employees for off-duty use. Ohio has medical marijuana available. As I understand it, right now, there is nothing in the Ohio medical marijuana statute that would say that the employee is actually protected for using marijuana for medical reasons off duty. New York, by contrast, has very strict rules that would get into pre-employment testing and enforcement based off of needing to establish both impairment and that the impairment was creating, a performance problem in the workplace. In Illinois, I can say I have reasonable suspicion of impairment and can discipline based off of that. New York, you can't do that because the rule is stricter. In New York, you would need to establish both impairment and that it was negatively affecting your job. So in effect, if I'm a better lawyer stoned in New York, I may be job protected. In Illinois, I wouldn't be. We have states and municipalities that we'll touch on, they talk about, pre-employment testing, not for cannabis not being permitted, and how that might impact you. And really the upshot of it is that you need to look at, both the state rule as well as the local, either municipal or county rule that may apply to you, because the chains and the ball may be moving at a local level, even if the state hasn't legalized, or it could be changing at the state level, even though the federal government has not legalized cannabis so far. And really, my view of this is largely driven around, the safety perspective of, the situation, because, I'm much more concerned about, employee safety and the safety of others who the employee might be coming into contact with. And, that in and of itself can be a difficult issue. It can also be a difficult issue if you're facing a situation where the employee isn't necessarily causing a problem, but and they know that that if they were to be drug tested, they can't pass the test. And perhaps they've given you a valid reason why they can't pass the test for cannabis. But that also means in the back of your mind, you don't know whether somebody who presents a card to you for medical cannabis that's authorized to do so under local laws isn't also out there doing something that could implicate the workplace. And we don't have very good tests to show when somebody last used cannabis and when they were impaired with cannabis. And that creates a concern because, it may not make a difference for, a desk jockey like me as a lawyer, because I can't, present much of a safety issue for Katherine. But, if I'm driving a vehicle, if I'm operating heavy equipment, if I'm using, something, like a saw or something, where somebody can get hurt, it really does make a difference, whether or not I'm impaired, and being able to stay on top of that, changes the risk landscape by a lot. So, the other issue that, we want to keep in mind is, in some cases, you may have DOT covered drivers. We're not really going to get into, DOT rules here, other than to say the DOT has defined safety sensitive positions. That definition of safety sensitive positions doesn't apply to non-DOT covered roles. If your employee doesn't have a CDL, if they're not driving a motor vehicle, you may think of them in a safety sensitive role, but don't make the mistake of trying to apply the DOT safety sensitive rules to your employees if they don't have a CDL and they're not, operating motor vehicle, commercial motor vehicles, because, in those scenarios, the DOT rule would not apply. But, if you do have employees who are in safety, if they're driving a forklift, or if they're driving the Zamboni at a park district, ice rink, those are definitely safety sensitive type roles, lowercase s on safety sensitive, as opposed to uppercase, under the DOT rules. And certainly we do know from highway safety data that states that legalized, appear to be having some uptick in motor vehicle accidents. It's not helpful information, from a can I sleep well at night type perspective. And you will need to be addressing, how you're going to deal with that if you can't just apply the DOT rule. We'll be talking about it. A lot of it is just training up on reasonable suspicion factors that we'll be touching on. In any state where the law changes on cannabis use, you need to look carefully at your policies. Certainly if you're in a state where you get a workers' comp discount for having a drug policy, definitely follow what those requirements are. There are typically notice requirements about informing employees what they're testing for, what their rights are, what the confidentiality issues are. Follow those because you'll get the benefit of it. Certain states like Arizona have also expanded that issue to some extent by saying that if you've published appropriate policies that check off all the boxes that are in the statute, you may be protected from claims of under the state common law that I think Katherine will be talking about in a little bit, saying that I was protected by the public policy of the state in my medical use of cannabis. You may be protected from a suit in Arizona if you have an appropriate policy. So you're going to want to dust off your policies and take a look at them against the state regulations to make sure that if there are requirements that need to be in the policy, that you've fulfilled those, because they may provide an additional layer of protection. The other thing to look for in your policy is to make sure that you've really defined the policy correctly around what employees can do and what they can't do. Because it's not that, it's not that uncommon for me to get a call where somebody says, hey, they flunked a drug test, and I fire them. And you take a look at the policy and you say, well, which policy, which part of the policy did they violate? I say, well, they flunked the drug test. You say, yeah, that's fine. But, your policy says possess on the workplace. Do you have evidence that they possessed? No. Impairment at work. Do you have evidence of impairment? No, I do not. Did they sell? No. Did their dealer show up? Did they buy? No. Okay. Where technically in the policy did the employee violate it? And if the answer is no, nowhere, your risk analysis of what you do with that employee that flunked the test may be very different as compared to a situation where you can clearly establish that there was a violation of the policy. For example, in Illinois, if your policy says that you can discipline based off of reasonable suspicion, and you give the employee the right to rebut the reasonable suspicion finding, you may have the ability to discipline the employee irrespective of the test. And, that's very helpful because, as you'll find out, these tests are not terribly helpful. So definitely look at the policies. If you have a policy that you're trying to apply across multiple states, you may need to dust off that policy and take a look at what the states are actually saying, because you may have to have special rules on a state-by-state basis now. Hate to break that to you, but that's one of the pitfalls of having state-regulated issues as opposed to federally regulated issues. So I touched on this a little bit. There's a DOT definition for safety-sensitive duties. I just want to highlight it a bit because it can create some confusion about, hey, DOT says if it's safety-sensitive, employees can't use drugs off duty. And that's true and very, very true, but it applies in very limited sets of circumstances. You're talking about CDL carrying employees who are operating commercial motor vehicles. And these are the factors. Is somebody getting ready to drive a truck? Are they inspecting the vehicle? Are they loading the vehicle? Are they driving the vehicle? And if they're not, even if they have a CDL, you should not be thinking of them as a DOT governed safety sensitive employee. You should not be applying the DOT testing rules because they may not apply. And if you're in a workplace where you have some people who are driving, some people who aren't, and some people who have driving duties, but they don't drive all the time, these are things that need to be analyzed very carefully to make sure that you're applying the correct set of rules, because it's easy to say if it's safety sensitive, you can't do it off duty, but you need to know what that means. And I call it capital S safety, capital S sensitive. And it's these factors about, what's the employee's interaction with a commercial motor vehicle? If there's none, it's lowercase safety, lowercase sensitive, and it's a very different situation. What you need to do with your forklift operators, your non-drivers, equipment operators, and that kind of thing, is make sure that your job descriptions really lay out, their safety sensitive nature of the function, and make sure that you understand those aspects so you can start to have an intelligent conversation with the employee who comes to you, maybe with a medical card, or maybe with a failed drug test, or a reasonable suspicion issue, so that you can be making the case of why it really matters, even in a state like Illinois, where off-duty use of cannabis is legal, why your restrictions are in place and what your rationale is for enforcing. Because, if you can identify who's in a safety sensitive role and what those risks are, you can have a much more thoughtful conversation about how you're going to want to enforce. Because in certain circumstances, you may be thinking, or your lawyer may be telling you, that the least expensive risk that's out there is that employment claim, because you may be having somebody who's operating a vehicle that's not a CDL vehicle, but that certainly is out there on the road that you could have potential liability for. And the harm that person can do if they're impaired while they're driving may far outweigh what their salary is, what a back wage claim would be, or the attorney fee claim that might come out of a wrongful discharge claim. That's a risk management decision. That's a risk analysis decision that's being made. And, but understanding where those safety sensitive risks are and where the liability is that could be coming at you, is important when you're looking at these policies and making the decisions. Some of this is above my pay grade or outside of what I know how to tell you about, but certainly those factors are there, in terms of third-party liability, and you should certainly be aware of them and have discussions about them as you're looking at your policies, as you're making enforcement decisions, and as you're structuring your programs. So I touched on this a little bit. detecting impairment. It used to be in the olden days, it was great, right? You could have a urinalysis done that would tell you whether in the last 30 days or so, 2 weeks, whatever it is, somebody used cannabis. They wouldn't necessarily be able to get out from underneath that. If you had a strict policy, you didn't want cannabis in the workplace, great. It was an easy deterrent. I didn't get a lot of questions about it. Now, the fact that there's a 2-week look back on, or longer on your standard urinalysis test, that's a problem for you. In states where off-duty use is protected, because now in a lot of states, including Illinois, your conversation is, hey, they failed the test. What does that mean? You can go to your medical review officer at the lab and say, hey, do you think they were impaired or not at the time the test was taken? And the answer you're going to get in most cases is no. And so, how do you enforce your policies in a reasonable way when your drug test isn't really necessarily giving you a lot of information? And that fact is what's driving in a lot of states like New York, a lot of municipalities. California is going to put it on the books in January 1, 2024. This is why we say pre-employment testing can be problematic, because your pre-employment test is only going to tell you what happened before the pre-employment test. It can never tell you what happened in the workplace. Is that useful information to you? It might be, it might not be. It may be something that's off limits. It certainly would be in Illinois, certainly would be in New York. And you need to be cognizant of that when you're structuring your programs in terms of what you're testing for and when you're testing for it. And, so we ask the question, is pre-employment testing, a viable thing to do? A lot of employers in Illinois that I talk to say we're not bothering with it. Why bother? It's just going to create more paperwork. It's just going to drive away employees. We can deal with it in the workplace based off of reasonable suspicion testing, or evaluations, and we can enforce off of it. Some cities, New York, as I mentioned, DC, Kansas City, Philly. I think with Atlanta, it's municipal employees. California is going to be doing it soon. They're just outright saying you can't pre-employment test. And, again, the reason for it is all it's going to tell you is what happened, while they were working for somebody else or while they were unemployed. It's not necessarily going to drive anything that's workplace safety related to you, other than the fact that in your workplace, you may now be dealing with somebody who, if they're tested on a random basis, or if they're tested on a reasonable suspicion basis, and they know that it's a distinct possibility that they're going to flunk the test. If they're in the road and they get, tested in the field because of an accident, they may not pass. And that may have implications for you, that may keep you up at night and create worries for you. In some positions, it won't. And you need to know the difference, by having good job descriptions and thoughtful analysis of it in the locations where your hands aren't tied and you can't do it already. What do I mean by reasonable suspicion? There's a DOT definition of it. Doesn't apply if you're not DOT. But what we're talking about are signs and symptoms that would reasonably lead somebody to think that somebody is impaired. And it's typically real-time things that you're observing about the employee. And it's that real-time aspect is why you want to have good forms for identifying what the supervisor, and in many cases, an additional witness, saw to establish the basis for reasonable suspicion. Because in Illinois, and I actually like this rule, I know I'm Illinois biased, but in Illinois, we can say, look, if we have reasonable suspicion of impairment, and we can document that and show it, based off of smell, based off of your behavior, based off bloodshot eyes, we can discipline based off of reasonable suspicion. That was the Illinois solution to the fact that the drug test isn't going to show impairment in the workplace. And so if you have folks who are trained and understand how reasonable suspicion works, and who are, have proper forms and documentation, and they're creating those documents, you can create a pretty good basis to show that, these were our concerns. The employee's behavior was creating an issue for us. Either we're a production facility, they could hurt somebody else, and we can see what's going on. We had 2 people taking a look at it. We talked to the employee about it in Illinois. They gave their side of the story, and we can move forward on the discipline. Now, you'll also see I talk about hunches. And what I mean by that is information that's provided to the manager, the complaint that comes from a coworker, somebody seeing low productivity, attendance issues, things like that. My advice to you on that is, discipline off of, poor performance, discipline off of, tardies and things like that. And if you can't discipline, go ahead and keep an eye on the employee. If you think that there's evidence of something happening, rumors, about things happening, strange visitors, things like that. Go ahead and keep an eye on the employee, but have somebody who understands reasonable suspicion, keeping an eye on the employee so that you can get that real-time understanding of what you're looking at. Because, people complaining, about, somebody's smell that the manager doesn't see, that's not reasonable suspicion. People complaining that somebody's late all the time, that's not reasonable suspicion. You're not showing impairment based off of gossip or other information. And you need to have that contemporaneous look at the employee that you're documenting. What are other reasonable suspicion signs? The odors could be, depending on what they're using, a hangover, needle tracks, nosebleeds, tremors in the hands, loss of concentration, things like that, lethargy. There are all kinds of, there are forms that are out there, where you can list off these things, and you should be documenting for that. And you should have folks who are trained to document for that and who have a second witness. Because I can tell you that, if you have an employee who, has reasonable suspicion factors like bloodshot eyes, smell, that kind of thing, if they come back to you 2 days later, they're going to be clean shaven. They're going to get a haircut. They're going to put a suit on, right? And so that complaint about something that happened 3 days ago, it may not be valid a couple of days later. It may not be valid if you're in front of a judge or an agency, because the person's learned to wise up, like, hey, don't reek when you're going to the EEOC to complain that this was unfair discipline. And so you need to have the documents, in place at the time it's happening, because it's powerful information and it's useful information. And if you do it right, you're going to be putting your best foot forward. So when you're sending somebody out, hey, do I have to be 100%, right? What if I send somebody out for a drug test and it comes back negative? Oh my God, am I going to get sued for that? No, if you have a proper program in place and people are trained and you're articulating why you're doing it and you're selecting people based off of, factors that you're documenting. If the drug test comes back clean, great, that's fine. It doesn't mean that you've slandered somebody or they can sue you. You're allowed to get it wrong. It has to be confidential, right? If you're blowing confidentiality, that's another story. But, get trained, document, and then, go forward understanding it's okay. Sometimes things are going to come back and you're going to find out that, the employee wasn't impaired, doesn't have a drug use. I mean, I'm aware of one circumstance where the employee came back and he said, thank you. And the reason for the thank you was the employee went to see the doctor to figure out what was going on, where, you had 2 supervisors saying, that they were seeing, reasonable suspicion factors. The doctor said, hey, did you know you were diabetic? The employee said, no, I had no idea. So that was the thank you, right? The employee got medical attention. The employee was dealing with a medical condition that they didn't know about and they wouldn't have known about, but for the fact that the employer said, we see your behavior as reasonable suspicion, sent them out for the test. Came back negative, but the guy's been a great employee ever since and was forever grateful. You can be wrong. It's okay. So, Katherine is going to take it, into, this issue of, well, what happens if the employee says that they've got a medical reason and, is it a disability? Do you have to accommodate for it?
Yeah, so this is kind of a tricky issue, and it's coming up a lot more often now as states are rapidly evolving with, some states have legalized medicinal marijuana, other states have not. And you get yourself into a really tricky situation when you have an employee who has a medical cannabis card, they show up with a positive drug test, and then they're terminated. And then they come back and they say, well, I have a disability. That's the only reason why my drug test came back positive. I'm being discriminated against based on my disability. And so as we'll see, courts interpret this in different ways. And it's, like I mentioned, a rapidly evolving area of the law. So first of all, the main federal statute that protects employees in the workplace based on disability discrimination is the Americans with Disabilities Act. The Americans with Disabilities Act, the ADA, protects you from disability discrimination, and it also entitles employees to reasonable accommodations in the workplace based on their disabilities. What's important to note, though, is that the ADA is a federal law, and also, as we've talked about, marijuana is still illegal under federal law. So federal courts have interpreted this pretty consistently, that the ADA does not actually entitle you as an employee to an accommodation based on your medical cannabis card. So you're not entitled to have your drug test, your positive drug test, be waived based on the fact that you have a medical cannabis card alone. Some disabilities that could possibly, implicate people who use medical marijuana are stuff like cancer, IBS, chronic pain disorders, MS, arthritis, and there's many others. But just because employees don't necessarily have protection from disability discrimination at the federal level, that does not necessarily mean that they don't have protections at the state level. So most states will have discrimination laws in place that protect employees from disability discrimination and also entitle them to reasonable accommodations. If you're in a state like Illinois, who has legalized medicinal marijuana as well as using it recreationally, you could potentially bring a claim under the Illinois Human Rights Act for failure to accommodate based on using your medical cannabis card, which is legal in the state of Illinois. So you're in a situation where you've been terminated based on something that's perfectly legal and actually prescribed to you by your doctor. Outside of disability discrimination laws at the state level, there's also laws that specifically provide protections for employees based on their use of medical marijuana alone. However, what we've seen across the country is that federal courts address this very inconsistently. And there's a lot of factors that go into it. And we'll talk about that. And then also, like Pete has already mentioned, a lot of states have more broad protections in place for employees based on their use of lawful products while off duty. So you can't discriminate against employees based on using lawful products while they're off the clock. But ultimately, regardless of if you're at the federal or state level, you're never going to find a law that requires you as an employer to allow employees to be impaired while on the job. That's never going to be okay. A court's never going to think that an employer should be allowing their employees to do that. There's also considerations for CBD products. So the FDA still maintains that CBD is illegal. And so this is a largely unregulated area as far as CBD products. A lot of these CBD products contain varying degrees of THC. And so this is something that I didn't know until recently, but even if you're using a CBD product, it's possible that if you take a drug test, it could still show up as being positive for THC. Because it's largely unregulated, it's hard to determine how much THC is actually in a product. There's no employment protections for the use of CBD specifically, like there may be for the use of medicinal cannabis, but this could still potentially implicate a disability discrimination claim. There was a recent case in Louisiana where the court ultimately found in favor of the employee, but for example, she was working as a customer service representative. So this isn't a safety sensitive job. And she had dealt with chronic migraines, and she was recommended by her doctor to use a CBD product to help with her chronic migraines. Ultimately, her work performance improved. She didn't have to take as much time off. The CBD product was working great. And then her employer told her that she had to be subjected to a drug test along with all her other coworkers. She warned them ahead of time that I've been using this CBD product. It's very possible that my drug test is back positive. They said, don't worry about it. You should be fine. She takes the drug test, it comes back positive, and then they fire her. So this is an example of someone who's a very sympathetic plaintiff here. Obviously, she warned them about ahead of time. She's using it for a medical purpose, and her job performance improved since using it. So these are all factors you want to think about when you're making employment decisions in this context. And then if you want to go to the next slide, Pete.
Sure.
Outside of these discrimination claims, you can also be, you could also face what's called an implied private right of action. So essentially it is a wrongful discharge claim. And this is a situation where an employee is bringing a wrongful discharge claim based on the existence of some other statute or regulation, common law, or some sort of public policy within the state. So for instance, even if I'm an employee in Illinois who was terminated, even if I maybe don't have a viable disability discrimination claim under the Illinois Human Rights Act or the ADA, I could still have the option to bring a wrongful discharge claim based on the public policy that using marijuana recreationally is legal, and I was terminated for doing something that was legal off the job. So that's an example of another type of claim that's out there. And again, courts are going to decide this inconsistently. Okay, so here's a pop quiz. Harry from HR.
So there was going to be a quiz?
There's a quiz.
Oh.
I know. Harry from HR calls Annie applicant to schedule a pre-employment drug screen. Annie's resume looked great, and her interviewers all reported good things about Annie. Harry is excited as he's had a tough time filling this job, and he thinks he has a perfect match with Annie. During the call with Harry, Annie states that she was at a concert recently where a lot of cannabis was being smoked. She wanted to give Harry a heads up that she's not going to pass the drug screen based on a possible positive result for cannabis. Harry knows that his company has a zero tolerance drug testing policy. And so the question then becomes, should Harry pull the plug on Annie's job application? Pete, what do you think about this?
I have to answer that? Oh, man.
Okay.
So, I mean, look, if you're in a state, that, or a location that bars pre-employment drug testing for cannabis, this is easy, right? Harry should not be doing anything. Harry should assure Annie that cannabis isn't on the panel. So that's the easy part of it. And that could be New York, that can be some of the, Philly, some of these municipalities that we've identified, California 2024, that certainly will be happening. What is, a little trickier would be, states where, cannabis is legal, for medical reasons, but, not recreational reasons, because Annie's saying she used it recreationally. So she's not, protected by, or she's not even saying she used it. She's not copying to that, but I'm going to say she used it because that's the kind of story my kids would say. Oh, I was next to the guy who was getting high, right? But so either way, it's a little bit suspicious, but she's not saying I have a medical reason for it. So in states where recreational use isn't protected in any way, shape, or form, the landscape may be a little bit different because, this private right of action that Katherine's talking about oftentimes is driven by, the medical protection that's available in some of the states where they're saying, look, there are medical reasons for this that should be protected and you can move forward. We don't have that here. So, if we're talking about a state where medical only is, what's at issue, Annie may not be in good shape for, having an excuse if she flunks a test or some basis to bring a claim. And that's, part of the analysis. In some jurisdictions, Harry's going to say, yeah, you know what, we're not going to do pre-employment testing because we need Annie and we don't really care about the pre-employment test anymore. And that may spur Harry to just throw pre-employment testing out the window anyway. But if Harry pre-employment tests, some people, but not Annie based off of the story, you've got a potential claim for disparate treatment because other people may be getting rejected and Annie's being allowed to come in. And, if Annie's under 40 and you have over 40 people who are getting screened out, that's an issue. And that uniform enforcement at that point wouldn't be there. But, Harry's situation is a little bit dicey because a lot of it depends on, where Harry's sitting at the time and whether or not Annie can claim any level of protection. I think on some level, she shot herself in the foot because she's not saying I used it. She's saying I was near somebody else who used it. So even in a state, that might say, that her use was protected, that's not really what her story is. So it's a little bit tricky. And, there's, sadly, there's not a clean answer. But, if Annie's in a state where pre-employment testing's not legal, that's her best bet to moving forward to getting that job. We want to touch briefly on OSHA and drug testing. This was more of an issue, a couple of administrations back, but OSHA, is always concerned about the tie between automatic testing and injury reporting. If you're going to the clinic for a work-related injury and they're drug testing you automatically, OSHA has said, from time to time, hey, we don't think you're necessarily getting valid information because that drug test for cannabis isn't really going to tell you whether or not somebody's impaired. So we're not sure why you're doing that. And if you're doing it to deter people, we don't like that. And that rule can rear its ugly head from time to time, and you want to watch for that. And, generally speaking, your better bet is to test for impairment when, there's some correlation between what happened and possible impairment in the workplace, or, making sure that you're getting the situation where, if I drop, if I'm operating a crane and I drop a load on Katherine and she's the one who got hurt, if you're testing her and not me, what are you really doing there? And so you would want to make sure you're sending me out as well, so that there's some uniform level of enforcement looking for that impairment. Otherwise, you might get OSHA a little upset with you. So now we've got the other issue, and again, this gets into, this problem of how drug impairment gets measured for cannabis, and the fact that you really can't. You got Harry, he fell off a ladder on a Monday, and he's not going to tell you about it until Wednesday. Why is he doing that? Maybe it's because if he'd been sent to the clinic on Monday, he was impaired. And so they're coming in, they're reporting it late. And I get this question a lot. Hey, can we send him for a test anyway? And the answer to that is sure, but you need to understand what you're going to get is a different picture than what happened at the time of the accident. You've lost the ability to get real-time information about what happened because of what the employee did in terms of delaying the report. If this were a DOT covered situation, by the time you found out about the accident, even if there was an obligation to test for the accident, which this isn't, you've missed the windows that the DOT would allow you to test for. And the reason for that is, if the employee is drunk on that, on the day of the test, they weren't drunk at the time of the accident. You can fire them for being dumb enough to show up drunk, 2 days later. But you're not getting real-time information there, and the utility of the information may not be there anymore. And so in many cases, the better course is to have, that policy in place that says, look, you have to tell us about what happens at the time of the accident. So we know that an accident occurs, so we can get proper information to our comp carrier, or God forbid, it's a safety situation where somebody else is going to get hurt because, the reason why you fell off was that there was a rung on the ladder that was missing, and that jerk didn't tell you about it. And so, on Wednesday, you're putting somebody else at risk because the ladder's defective. You're on much more solid grounds if he's creating safety issues for you by not reporting the accident right away, and you want to discipline him for a late report. OSHA sometimes hates the late report discipline issue, and you have to watch for it. But if you can show that he's created other downstream problems, you're generally better off saying, look, our problem with you is that you didn't tell us about it when it happened. On reasonable suspicion, it's really important. Like I said, somebody who comes in looking, like smoking pot might look like a Boy Scout 3 days later after they've been disciplined if they're going to meet with an agency person. And so it's important to get good documentation of reasonable suspicion, because in a lot of states, that's really all you've got, because the drug test for cannabis isn't going to help you. And so you want to have folks who understand what they're looking for and who know how to write it down carefully. Because, saying, hey, I thought they were drunk, or I thought they were high, it's not, 2 years later, if you've been involved in dragged out information, that's not useful information. So you want to be communicating what you actually saw. What were the reasonable suspicion observations? Uncoordinated behavior, smells, things like that. Describe those. Don't just lump it all into, he seemed like he was high, because you're going to kick yourself later if you do that. And that needs to be part of your reasonable suspicion program. So your best practices at this point, take a look at what's going on in the states around you, and build your policies around what the states require and what they allow. You also really want to think about, in states where it's protected, do you want to have mechanisms where employees can bring forward issues like, hey, I'm on CBD and I need it for medical reasons. Somebody who's on CBD, even if they're going to trip up a cannabis test, they're not getting any of the fun typically, right? Because it's a low THC product. And so you want to think about, the information gathering so that, again, you can make informed decisions. And you certainly want to make sure that your managers understand what is reasonable suspicion and how do you define it so that you get good paperwork, because really that is your best tool for enforcing cannabis in the workplace, is being able to say, I thought this person was impaired and this is my concern. So we've got a couple minutes left, and let's take some questions.
All right. That was a lot. Okay, we've got.
That was a lot. I'm sorry. Well, we do have 50 states worth of problems, right?
Yeah, I know there's so much gray area here. So, okay, do we have to officially label a job as safety sensitive, or is an OSHA defined task sufficient? What if the employer deems it safety sensitive, but the government does not?
If you want to have it defined, you want to know what your safety sensitive issues are with respect to the policy, because a government regulation, a definition, yes, it applies and is very important in the DOT context. In the non-DOT context, you want to know what the risks are and where they're at, and you want to be able to articulate them, because you may need to justify it to an agency or a judge later. And the better handle you have on it and the better documentation you have on it, you're much better off, because if you don't have it in place, you're much more open to, you made it up after the fact. This sounds like pretext to us, and you're going to be, on less firm ground.
Okay, great. This one says late report of a workplace injury to avoid drug screen at the time of injury is suspected. What recourse does the business have?
Again, it's if you have a policy that says we can discipline you for reporting late. You want to look at that policy. If you don't have that policy, you may want to put that policy in place, because presumably the employee is smart enough to know not to show up impaired. And so you're not going to get a reasonable suspicion, and you don't have real-time information as to what happened at the time of the incident. And so you want to look at, well, what happened, during that accident? Was there property damage that you don't know about until, 3 days later? Was there an unattended safety risk that, you don't know about for 3 days later? So you can build the case that that late report really mattered and really hurt you. And if you can do that, then you're on pretty good grounds to say, hey, that late report was really a problem and we're going to discipline off of it. You have to watch that though, because what OSHA doesn't want is the situation where the employee gets hurt, they don't realize what the issue was. A couple of days later, they're getting the symptoms, concussion symptoms, after banging their head 2 days ago. And the employee's afraid to come forward now to get the treatment that they need, because they know that you've got this immediate reporting policy and that you might fire them. And you have to watch for that as well. And so that's why I say, look for, did they create a safety issue for other workers, or a property damage issue, or something else that you can point to, other than just, yeah, maybe you didn't realize what happened. Maybe, you only came in when it was a raging infection on the cut, but, otherwise it didn't really impact you. Because if you do it then, you do run a risk that OSHA is going to say, you're just trying to drive your injury report rate down by having these draconian policies in place.
Yeah, that's a good point. This is an interesting one. Can we decide not to hire someone with a medical marijuana card?
That one's tricky, because then you are brushing up against the issues we talked about in the context of disability discrimination. So if we're talking about pre-employment, we touched on those issues. You really want to consult what your state says about the use of not only lawful products off duty, but also certain statutes in place that specifically provide protections for employees with medical marijuana cards. So it's really going to depend on the state, but it's something that you definitely want to be mindful of before making a decision like that.
Yeah, when you take that to your attorney, I would also make sure that the attorney understands what's the safety reason for it. Because my answer would probably be different if you were telling me that it's a clerical position or something where nobody's going to get hurt, as compared to, you're driving a vehicle out on the road and you can put people in at the risk of harm.
It's 1 o'clock right now. Do you have just a couple more minutes to answer, like two more?
You told us we were your favorite people, so of course.
So now you have no choice.
Right, exactly. I don't want to lose my status.
Excellent. Okay, this one is a good one. Does our policy need to clearly state which type of drug test the EE will be submitted for?
In many states, the answer to that is yes. It's driven on a state-by-state basis, and oftentimes you want to look at your comp laws, because there are states like Arkansas where you can get the benefit of a discount for having a drug testing policy in place, but you have to follow the list of their requirements, and that list of the requirements includes telling people, what the drug testing panel is. Arizona has a similar rule where you can be protected from liability on these common law claims that Katherine was talking about. But one of the things that has to be in the policy is a list of what you're testing for. In Illinois, we don't have that rule, but there are a number of states that do, and unfortunately, somebody's going to have to look that up for you.
Okay. This one asks, could the company encounter problems by enforcing a mandatory drug test for all WC claims, regardless of the type of injury?
Possibly, a lot of that gets back to, what's Doug Parker going to do with OSHA? Because that, oftentimes is an OSHA issue, where they're saying you're using your drug testing policy, as a cudgel to avoid having employees report injuries. And that, certainly upset OSHA in 2016. It went away. I think it's possible that, OSHA is going to get around to resurrecting that concern, primarily because of the issue of, the way OSHA put it is, if you get stung by a bee, were you really, potentially impaired when that happened? And what information are you using? Or why are you gathering that information? So I would watch for it. It may be defensible. Talk to a lawyer about it and think about your rationale for it. You may not, necessarily upset OSHA, but if you implement it and then you're uploading 300 logs and all of a sudden your injury rate drops down, by a ton, OSHA's going to see that electronically, and they may poke around and want to know what's going on.
Okay, I've got one more here that says, if an employee comes to work high on cannabis, can they be sent home without pay?
Wow. God, Pete.
You want it?
Oh. I mean, that one's an easier one. I mean, you can send them home for sure, because like we talked about, no matter what, you never have to allow a situation where an employee is actively impaired at work. You do have to pay them for the time that they actually worked that day, but you're certainly able to send them home if they're impaired and not pay them for the rest of their shift.
Would you bring them back the next day?
Sure.
Would you?
Or, I mean, it depends. I don't know. They're
I wouldn't. Right? I mean,
well, bring them back to maybe talk to them and have some sort of disciplinary action taken, depending on what your disciplinary policy looks like. But yeah, that's a serious issue if they're impaired on the job.
Yeah, I mean, New York is a little bit weird on this one, because in New York, the impairment alone isn't going to be the problem. In New York, it has to be impairment leading to decreased job performance. So I'm not sure how you tackle that in New York, where somebody shows up obviously impaired. Do you have to let them, fumble around a little bit before you send them home? But, in many other states, if they show up impaired, you've got a policy that says you're not supposed to be there impaired, and you can enforce that.
Whew. This is tough stuff. There's just doesn't seem to be any like real concrete answers to this stuff, because rules are different everywhere.
Right.
Yep.
I mean, this is what happens when you don't have a federal rule and the states decide to get ahead of the federal requirement, and it makes it very tricky. And that's why we need to have webinars. That's why we need to have resources like HRsimple, where you can get at information on your state specific requirement, because things aren't always well published in terms of what the rule is, and being able to get that kind of guidance right away is important.
Do you think that there ever will be a federal rule coming anytime soon?
I don't, I know that there's that there's pressure to do it, but no, I don't. At this point, I don't see any move to get cannabis off of Schedule 1 at this point, or anything meaningful like that. I just don't see the momentum for it.
Interesting. Okay, well, we'll just keep having these conversations then.
I know, right? That means you can bring me back every year to keep talking about this stuff, right?
Definitely. Thank you both so much for that. That was such amazing information. I put Katherine and Pete's contact information in the chat. I will also include it in the follow-up email that goes out, but we really appreciate both of your time. This was so insightful. Thank you both so much.
Thank you.
Thanks for having us. I'm so glad that more than 50 people came out to want to hear about this. And we really appreciate everybody's time. Thank you.
Definitely. Okay, we will bring you back soon. Thank you, everybody. I hope everyone has a great day. Bye-bye.